Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. As soon as we get our self situated up here, I'll introduce the panel for you and go over the ground rules, and then we'll get started. First of all, I want to take the opportunity to introduce the panel to you this morning. To my right is Judge Arnold Golden from Memphis. To my left, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. And we will be your panel for this morning. I know that all of you are experienced practitioners, been here before, but I want to take a moment just to touch on the basic ground rules. First thing I need to advise you of is that we are live streaming all these arguments, so keep that in mind as you are making your argument, because this is going out just as you are saying whatever you're saying. So if you don't want it to go out, don't say it. Second thing is each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time. The process you use to do that is after you've introduced yourself, you request that from the court. Obviously, the appellee gets no rebuttal time. Ms. Angie, anything we need to take up before we call the first case?
No, Your Honor.
All right, you may proceed. Call the first case, please.
Charter Communications Operating, LLC versus Madison County et al.
Glad to see there's no prohibition against allowing older lawyers in the courtroom.
No, sir, I'm just glad to be here for social interaction, to tell you the truth, as I say. My name is Jim Pentecost. I'm with the Madison County Bar. And myself and Ms. Barnett represents the appellates. We ask for 3 minutes of rebuttal time.
3 minutes. Are you going to be the only one arguing?
No. Okay. I will basically argue for the first 6 minutes. Ms. Barnett will argue for the next 6 minutes based upon the fact that there are 2 appellates, and I hope this is not eating into my time.
Well, it's not eating into your time, but we need to be sure and make sure we've got the timer set so you can know what's going on.
Yes, sir.
Okay.
As I said, I've already introduced myself. Basically, as to the division of time, this case has been briefed substantially. I would say that most of the law has been decided. Most of the parties do cite to the law. What we do have a difference is concerning the application of the law, and one of those examples is in the brief as set forth by charter on page 34. Talking about the standard of review, it says the scope of review by the appellate courts is no broader than that of the Chancery Court in these cases with respect to evidence presented before the board. The reason that is a correct statement of law, but there is a presumption that I believe that charter is attempting to make. And that is, first of all, there is no presumption of correctness as it relates to what was undertaken by the trial court. The next example is that even though you don't have, this is a de novo hearing, and this is a de novo consideration of what was ordered by the trial court. It is correct that this court should put itself in the position of a chancellor. And respectfully, I think that's easy for all 3 of you to do, to put yourself into the position as a chancellor concerning review of this matter.
I assume that standard of review, the standard of review that they're talking about is that the Chancery Court essentially was also sitting as an appellate court in that stage, wasn't it?
Well, I think it is sitting as a review court as it relates to what was decided by the Finance Committee of Madison County. I don't think it's an appeal court because you don't have the same burdens that are placed upon charter as it relates to a presumption of the evidence, as it relates to introduction of witnesses or exhibits or things like that. So there's a difference between that.
And there's some limitation on the review that the Chancery Court can conduct.
Yes, sir. And Your Honor, that's why I have a problem with the cited as it relates to the cite to Waste Services Decatur by saying that it almost gives a distinction that it's broad. Well, Your Honor is correct. It's not broad. It's very limited. And what I ask you to do is take your position as a chancellor when you look upon your docket and you see that there is a writ of certiorari concerning a bid hearing. Now, I don't know what you did when you were chancellor, what you internally thought about that, seeing that on your docket, but what you do know is that the law is, in general, courts don't like to get involved in these matters as it relates to the purchasing and as it relates to the providing of services and the termination of those services by a governmental entity. That's the first thing that comes to your mind when you see that upon your calendar, is that you don't like to get involved. You shouldn't be involved unless there are specific examples of it. Then at that point in time, after you know what that duty is, you even have further limited review. It is there any material evidence to support decision of the committee? Did the committee act illegally, arbitrarily, fraudulently? And then third, was the bid done by state law? After you have looked at those two situations concerning what is the role of the court, the next decision that you make as a chancellor was this a final decision? It's not, a writ is not appropriate unless you have a final decision. And I'm having no time on my clock about that. But anyway, I will proceed as if I still have 6 minutes. And basically, that
you can do that if you want.
I have a feeling I know what will be said to me. Yes, sir, Your Honor. But basically, what you have at that point in time is that you see if this is a final decision. It was the only thing you consider is the final decision of the Madison County Finance Committee. And yes, this was a final decision. It was based upon state law. One is that the bid was specific in its form. It was public. It was published. It was given notice to. The next thing that you look at is the state law, and that is it following the procedures as set forth by the Madison County Finance Committee? And yes, it was. It was bid. It was reviewed by the Jackson-Madison County School System. After that review, it was reported to the Finance Committee, the Department of the Finance Committee, as to who they believe should receive the bid. At that point in time, it's not over. Yes, sir.
Let me ask you a question about that. In reading this material, and I'm certainly not as familiar with it as all the council are, but I had a question about whether this removal, this cost of removal of equipment, the cost of removal of equipment and out of a bunker.
Yes, sir.
Was that included in this bid?
Well, Your Honor, it was included in what was to be considered because it's clearly defined.
That's not what
it is included.
It's not what I asked you. Was it included in the bid?
It was included in what the specification of the bid was. It was included as it determined that it's to the best bid. Not only the lowest as required under state law, but also the best bid. The best bid you consider outside factors, and that was an outside factor that should have been considered by charter.
Was it a factor that was directed to be included in the bid?
Yes.
Okay. If you read the specs of the bid, it says also included is this removal of equipment issue.
Well, it also says ineligible services. And this bunker is an ineligible service under E-rate. And I'm not going to sit here and argue E-rate, Your Honor. That's why we have experts. That's why we have people that advise the Madison County Commission as it relates to that. And so, yes, it was included. Yes, it was considered. It is not a part of the contract as it relates to reimbursement of cost, Your Honor.
Okay.
In other words, yes, sir.
My question is, was that information available to all the bidders?
Yeah, pick a phone call. All you had to do. It's also referenced by Mr. Bone.
Would you know to make that phone call?
If you are supposedly experienced as Charter is, and as experienced as you are in dealing with E-rate, as the experts of E-rate, yes, sir. You do know to make that call because you have to determine whether that hardware, again, don't know anything about computer hardware to a degree, but that hardware is in a centralized location that was determined by Miss Rosemary many years ago. That was what was best for the school system, to protect that hardware, to have it in a secured bunker. In other words, it is not standalone sites at each school. I'm red.
Yes, you are.
I would like to say that when you also look at that review, Your Honor, you're not considering your own thoughts, comments, or decisions. You're looking at the Madison County Finance Department. Thank you.
Your Honor, it says 1 minute. Oh, she's going to reset it.
Now you're good, you go.
Thank you. May it please the court, I am Sarah Barnett, and I'm here on behalf of Jackson Energy Authority, which was actually awarded the bid as the lowest and best bidder. And you can see that the standard of review is a big deal in this case. And this case really boils down to one question, and that is whether there was any material evidence to support the finding of the Finance Committee in awarding the bid to Jackson Energy Authority. And of course, or were they acting arbitrarily and capriciously? Did they flip a coin in deciding what was going to happen? Or were they acting illegally? The answer to the question is that the Finance Committee had material evidence upon which it could base its decision, and that was saving money. And that's a rational basis for any committee to make a decision in awarding a bid. In this case, it was substantial. It was $250,000, essentially. And so where the problem in this case occurs is when the trial court took a look at this, and Mr. Pentecost talked about the trial court acting as the chancellor. And Judge, you're right that it is very limited in scope, and it's not actually, I wouldn't call it acting as the chancellor. I think that he probably did what most chancellors do, which is act as the trier of fact in a lot of times. And that was, respectfully submitted, that was beyond what he was supposed to be doing. And you can tell this in looking at the order, because there were 3 reasons that the court gave for why it was overturning what the Finance Committee did. And the first related to the matrix, or the scorecard. And I'm sure you've seen this. This is part of the E-rate process. When school systems are reviewing the E-rate process and the bids, they use this scoring matrix to determine which bid is the one that they should select, which bid is the most cost effective. And price has to be the highest weighted. And in this case, the scoring matrix, price was the highest weighted. Charter had the lowest price on its face, and so it was given the highest bid. Now, the issue with the trial court was that the Chancery Court looked into the bid matrix and started giving its own ratings for that. Now, the bid matrix was not scored by the Finance Committee. It was scored by the Jackson-Madison County School System and its E-rate expert, and they took their time and went over all kinds of details that we're not really privy to. And so what the chancellor did was he rescored it himself. And of course, the case law says that one of the things that a judicial review is not to entail is to address the intrinsic correctness of the information that was presented to the administrative agency. And that is exactly what the court did in this case when he was reweighing the scoring on the matrix, and he found that arbitrary and capricious. I think a similar...
Are you saying that the trial court can't question the scoring?
Your Honor, what I would say is, actually I would say yes, and I think the case...
So, Charter gets how much on cost?
25.
And your client gets how much?
23.
And there was how much difference in money?
It was, I don't have the number on the top of my head, but it's pretty substantial, a difference.
Pretty substantial. Was that ever explained?
Your Honor, I would say that yes, Rosemary Enos, who's the E-rate expert, she did explain that, not in great detail to the committee, but what I would say to you is that That's not what the judicial review is about. And a good example of that is the Powell versus Parole Board case. And that was, Mr. Powell said to the parole, appealed what the Parole Board held because they had miscalculated, according to him, they had miscalculated his when he could be released. And the Court of Appeals said, sorry, we can't look into the correctness of that.
I agree, that's what the law is. No question about that. I'm trying to sort this out in my mind as well. How many bidders were there?
There were 4.
Okay. Same question that I asked Mr. Pentecost earlier about the bid itself. There seems to be a lot of concern about moving equipment about, and I'll just use the generic term, the bunker.
Yes,
Do you agree that was included in the bid?
I do. And I think now I would say this, it doesn't say it will cost $600,000 to move the JEA, move out of the bunker. It does not say that. What it does say.
Include, what does it say?
What it does say is, so the second line in the matrix is, and this is provided to the bidders in advance, so they know what the scoring is based on. And so the second line in the matrix is other cost factors. And if you look at it, it's actually on page 13 of our initial brief. It shows that it includes the price of changing providers. And certainly, given the experience of these bidders in this kind of context, they know that there are prices involved in changing and moving equipment and that sort of thing, changing over. They've been with JEA for 15 years. There were going to be costs involved in that. The bid also says that
Was that a definition? Is that what you just stated?
Your Honor, that comes from the bid matrix itself. It's the second factor of the bid matrix, and in parentheses, but besides other cost factors, it says, quote, price of changing providers. That's one of multiple factors.
So that's where it is. So that is in the bid.
Yes, Your Honor, it is. Your Honor, I'm out of time. Thank you.
Thank you.
Good morning, Your Honors. May it please the court, my name is Russ Morgan. I'm here with my partner, Richard Swore, from the Nashville Bar. We represent Spectrum, chartered doing business as Spectrum. Respectfully, I'm going to state that the trial court should affirm, the appellate court should affirm the trial court's decision, finding that the ruling by the Finance Committee was arbitrary and capricious and not supported by material evidence, but the appellate court should go a little bit further. And the appellate court should actually say that this award should go to Spectrum, because in this particular instance, there was a relationship between JEA and the county that makes it an illegal arrangement. And this is clear from the papers, because JEA had stored the computers for the county or for the school board under an exclusive relationship. And the only reason that it would store that equipment is if the county gave it the E-rate bid. And because you have this relationship, that's an illegal arrangement that would, in this particular instance, create an unfair advantage, which is strictly prohibited.
So you think we've got the authority to do that?
Absolutely you do.
At this juncture?
Absolutely you do.
Did you ask the trial court for that relief?
Excuse me?
Did you ask the trial court for that relief?
Yes, we did.
Okay.
And the Harding Academy case sets forth that you actually do have the authority to make a ruling when the agency acts outside its boundaries. The appellate court has the ability to tell the trial court to go and reverse that and award. In that particular case, it was to award a permit that should have been awarded by the agency. In this case, it's to re-award the bid to where it should go, because JEA is a disqualified bidder. I mean,
well, before you get into that, let's back up and
Sure.
start at the beginning. Why was this bid, or why did the court find this to be arbitrary?
well, the court found it to be arbitrary because for two reasons. First, because the scorecard that was provided, and the court pointed this out in its argument with the opposing counsel, There was a price difference of $374,000 between, it's undisputed that Spectrum's bid was lower by $374,000, which is a significant amount of money in this particular context. Yet the pricing on that was 25 points to Spectrum, 23 points to JEA. On another, for instance, there were several other categories that they scored, one of which was uptime. And JEA said that it had 100% uptime. Charter says we have 99.99% uptime. And on that particular score, JEA gets 10 points, Charter gets half of that, 5 points. And there were 3 other categories where the scoring was very much pro-JEA with no, for instance, JEA's position that it could support a fiber input. Well, Charter has the same capability, but JEA was given 10 points and Charter was given 2 points. So the scoring by the board was just, there was no rational basis. So that's why he found, he didn't reweigh it. He just said, looking at these scores, based upon the evidence before him, there's no rational basis for those scores. And so, therefore, it's arbitrary and capricious. And he also made a determination that the consultant that presented her testimony and said that there was a $650,000 difference in terms of removing this equipment, that there was no support for that. I mean, and they say, well, under Rule 702, she doesn't have to introduce evidence, but they do have to prove that she's an expert. Everybody on this court is very familiar with the Daubert requirements of an expert, and they did nothing to proffer. She's an E-rate expert. She's not a technology expert. She's not an infrastructure expert, yet she came in and gave testimony on the cost removal. And I want to speak to one specific point. There was nothing in the bid about the need to relocate equipment, and that is, I mean, imagine a situation in this particular instance. What you've got is you've got an internet hookup, like it's going to be on your house. Now, if an internet company is going to be hooking up to your house, how's the internet company to know that the actual location is someplace else, and that if they can't hook up to that location because that location won't allow the internet company to hook up there unless because of competitive disadvantage? In this particular instance, and I'll show you and I'll cite you to the record, there was a list of locations that was included in the bid, and it's the record on appeal number, page 739. And there's not a JEA bunker listed on this. What's listed is the Jackson Madison County School System Central Office. That's where you would think that a server stack would be. So in this particular instance, what you have is all businesses have server stacks, or these days they may have a cloud. Those server stacks typically are on the business premises. In this particular instance, the school system's server stack was located at JEA. The only reason that the school servers were on JEA is because JEA allowed them to keep their servers there as long as JEA also got the E-rate contract. So if JEA did not lose the E-rate contract, then they would keep them there. But if JEA loses the E-rate contract, then the new provider has to go and move that equipment. That's an unfair advantage to JEA. It's strictly prohibited.
So are you saying that with your client being in the situation that they are and being in the business that they're in making this bid, I mean, obviously your client services a lot of other school districts and municipalities, things of that nature. In making this bid, that was not something, the location of, as you call them, the server stacks, was not something that your client would have taken into consideration?
Absolutely not. The fact that one of their competitors is storing the server stack and would not allow them to continue, the fact that JEA is storing the server stack for its customer, its E-rate customer, is highly unusual. And so the concept that if they're going to lose the bid, and it's illegal. It's illegal for JEA to say, unless we get the E-rate bid, you've got to move your server stack. That's a bribe. That's a rebate, so to speak. So that kind of arrangement doesn't happen in this industry. And USAC, the federal government, would not allow that to be permitted for them to have a contingent relationship to store the server stack. Under a normal circumstance, the server stack would be either at the administration's office. That would be the normal way. So if you go from JEA to Spectrum, there's no change. All you do is you run the line to the new line to the building. So there's no change in relocating the equipment. It's highly unusual. It's extraordinary to have to relocate the equipment because you change internet providers.
I've heard a lot of argument from both sides about this issue. What was presented to the commission on this matter? Because the commission...
What was presented to the issue? Well, as the court's aware, the bid was awarded before there was ever a determination by the finance director. The school board entered into the contract before it went to the finance director. We showed up at the bid protest hearing and got the award for the first time. And then Ms. Enos, who's not an expert in infrastructure relocation or equipment relocation, gets up and all she says is it's going to cost $650,000 to move the equipment out of JEA because JEA is not going to allow that equipment to stay there unless they win the E-rate contract, which that was the first time that was ever presented that this equipment was located at JEA. She called it a network operations center. It's as if they're doing business. They got their network operations center off-site at JEA, which might be appropriate, but it can't be appropriate if it's tied to the E-rate contract. It's considered to be a carrier-neutral site. It's supposed to be a carrier-neutral site. So even if JEA didn't win the bid, we should still be able to hook up to JEA, just run the line, just like the lines run to your house, and then you're plugged in. But what they're saying is because JEA won't allow its competitors to run the line into their facility, that equipment now has to be moved. Let's flip it around.
Well,
let's assume...
Let's go back to my original question. So how much of this is in the record?
All of it.
I thought you said at the bid protest that was all...
At the bid protest, they brought up that they had to move the equipment to JEA. That part's in the record.
Right.
That's right.
So how much of this argument that I'm hearing is in the record?
That the equipment had to be moved from JEA. I may be misunderstanding you. That evidence was in the record that the equipment needed to be moved from JEA to someplace else because JEA will not allow equipment to be located there. That was in the record. That's the amount of it.
Or is it in the record that essentially what I'm taking your position to be is that that wasn't part of the bid?
That was not part of the bid. That was not part of the bid at all.
Is that in the record as well?
That is in the record.
That's before the finance committee.
There was never a mention of having to relocate equipment in the bid. What they say is this is part of the other cost. I mean, you may have some incidental cost in switching providers, obviously, but you don't have a cost of $650,000 or $750,000 to relocate equipment. That's the difference. Most businesses, the equipment's located on their premises. Maybe it's located at a third party, but it's not located at a competitor that the contract's tied to being there. So, Your Honors, so as it relates to the record, what was in the record was that we had this other cost. There was no explanation that the only reason that other cost existed was because JEA had a relationship with the school board and would not allow that equipment to remain there. That was new information to everybody because it's not in the bid. It was never in the bid to begin with.
That's what I've been trying to get to.
That's right. That was not in the bid. There was never a specification that if we're going to change providers, the competitive bid process in this particular instance was illusory. And they've admitted it. Both parties have admitted. And Ms. Enos stated it, and I'm going to read this real quick if Your Honors will allow. JEA admitted that its server storage is only available to customers. It says, JEA rented its space in a secured bunker to JMCSS to house its 111 mission-critical servers. This is a service that JEA provides exclusively to its customers. And then the school board admits that, and Ms. Enos goes on to say, it doesn't matter whether it's Spectrum or WANRAC or Thomas Consultant Incorporated who also bid. If we switched to anyone other than JEA, we knew that we had an outright cost right now that the school district would be paying between $600,000 and $750,000. That was never in the bid anywhere. Because if any three of these bidders would have known that, they wouldn't even wasted their time bidding. They're not going to be able to do that on this size of contract. That was never in the bid. And then the county summed it up by saying the estimated $750,000 to $900,000 in the server relocation and IP address change made JEA the only logical source. If JEA is the only logical source, if the other three parties cannot possibly win, it's an illusory competitive bid. And it's a violation of Tennessee law, it's a violation of county law, and it's a violation of federal law. The Madison County purchasing policies say, no specifications shall be written and submitted to the Finance Department that intentionally would unfairly eliminate or limit submittals from other qualified suppliers. And that's exactly what's happened. Because they have this relationship, this exclusive storage relationship with JEA, no other supplier could possibly win this contract. And so that's what's happened here, because no one else can win. And they've admitted no one else can win. It's the only logical choice. Here, you've got Spectrum was $374,000 lower on price. In order for Spectrum to have won this bid, they would have to basically pay $374,000 and then come out of pocket another $400,000 to even be able to compete with this bid. And that's not what a competitive bid's designed to do. And it's because there's this unfair rebate between JEA and the school board. And that's why, Your Honors, and Judge Davies, as much as I respect him, got it wrong on this. That's why JEA is prohibited from bidding, even under, and I'm looking at Record on Appeal 473, the school board's own rules identify that when there's a relationship between the bidder and the agency, the bidder is prohibited from bidding. And here it says the school board has to eliminate unfair competitive advantages. Contractors to develop or draft specifications, requirements, statements of work, invitations of bid, requests for proposals must be excluded from competing for such procurements. Some of the situations considered to be restrictive of competition include, but are not limited to, placing unreasonable requirements on firms in order to qualify them to do business, organizational conflicts of interest. And that's what you have here. You have a conflict of interest because JEA says, unless you give us the E-rate contract, we're kicking you out. You can't do that. That's a violation of federal law. I mean, this is a federal contract. You cannot say if, then. And that's the problem here. So not only should this court set aside the bid award by the Finance Committee, because clearly it's undisputed that, forget about the bunker. If you forget about the bunker, Spectrum was the lowest bidder, and Spectrum satisfied equally every single bid requirement. The only difference was Spectrum wasn't holding the server stack that JEA was. And so if you've got to, so the bid award needs to be set aside, and this court should say JEA cannot compete because there's no way you can comply with Tennessee state or federal law on a competitive bid process. So, Your Honors, I thank you very much. I respectfully request that you affirm the decision of the trial court, but go a bit further and determine that this award needs to be awarded to Spectrum in order to be compliant with federal, state, and local law. Thank you, Your Honors.
Thank you. I think you got 3 minutes, Mr. Pentecost.
Yes, sir.
What do you say about this idea that this was an illusory bid?
I'm sorry.
I said, what do you say about the argument that this was an illusory bid because nobody other than JEA could win this bid?
First of all, I would say that the JEA contract was done by state law. It was bid, it was reviewed by the Finance Committee, and therefore it is a proper contract between JEA and the county and the school system as it relates to a cost to be considered concerning the bid. And Your Honor, I'm sorry, go ahead if I didn't answer your question.
My question is that how could this be a competitive bid under that fact scenario?
Because what would occur is that pursuant to the terms of the contract, and now it was marked for identification purposes, and it was submitted into the record, but it was not part of the record as it relates to the Finance Committee. Because Charter made what I consider to be very inappropriate comments about free services, not having a contract, that violates federal law, and in fact, in their brief, they even cite to what Mr. Bones said, which was their person who testified at the hearing. He said there is no relevancy there. If there's any relevancy there, in E-rate, there's a very rigid rules that you can't give something free in order to get a bid for other E-rate eligibility. And what is the point here is that there is a contract, there is consideration paid for that contract, and that contract can be terminated if JEA is not part of the bid. Now for them to stand up and say that's something that no one considers, where I point to the record, I'm sorry, I don't have this is the certified record that was presented to the chancellor to consider. And in that matter, Mr. Deaton, who is a member of the Finance Committee, says, tell me about this cost. Tell me about the cost of moving it. And he asked that of Mr. Bone of the charter. And this is what Mr. Bone specifically says. He says, and like I said, sometimes when there is an ROI, which means a change of service, it's done on changing a carrier. A big part of the ROI is the cost that the new carrier passes on for constructing, which relates to, and then he gives an example of where they did that with the school in Kentucky. So for them to stand up here and say, we don't know anything about that, that's not considered, here's their own person that testified before the Finance Committee saying, yes, that is a consideration to be made in all E-rate contracts. And Mr. Deaton asked about that, and he wanted them to tell about that, and they admitted that was cost. And the testimony of Miss Rosemary, of Miss Ennis, who gave all her qualifications upon the record as being an expert and why she should be used by the Finance Committee as to these material facts. And basically, because of what the court did of taking its own judgment, then the trial court should be reversed. There is only one as to the writ, and that is to deny the writ and this court dismiss the complaint of charter. Thank you.
Thank you, counsel. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. We appreciate your arguments, your briefs, and you may be excused.